the floor then to my colleague Eva in a few seconds. So again, thank you to all of you for joining us today to this webinar, which is called, as you know, Strengthening the Rights of the Child in Administrative and Judicial Proceedings Related to Migration, Implementing the Council of Europe Guidelines on Child-Friendly Justice. So as you may understand, the webinar is really about the importance of applying those principles of child-friendly justice in the administrative proceedings related to migration involving children, if we want to have the rights of the child, actually of those children, respected. So we will have some examples, and you will see during these presentations, during this webinar, some concrete examples from my colleagues. But first of all, I just would like to go very quickly through the agenda. So I will have an introduction, a very brief introduction to give you background information on the project on which this webinar is based. Then I'll give the floor to Eva Garnier, my colleague at DCI Belgium, and she will make a presentation on some aspects of child-friendly justice. I can see from the polls that half of you are actually not really familiar with the child-friendly justice principles, so that's a good opportunity to have this quick presentation. Then we'll go to three country-specific topics presentation. The first one will be done by Giulia Pamias from DCI Italy on the role of volunteer guardians for unaccompanied children in Italy. Then we will give the floor to my other colleague in DCI Greece, Spiros Aperlis, who will make a presentation on the importance of early access to legal support for unaccompanied children in Italy, in Greece, of course. And then Eva will come back to give you a presentation on how important is to consider the best interest of the child for accompanied children in Belgium. So this is mainly the three main topics that we will cover. Then Eva will come back to give you some advocacy, presentation on some advocacy opportunities at EU level. And finally, of course, we will have a Q&A session. So I hope you'll enjoy. Altogether, the webinar will last an hour. So let's start without any delay, just to give you, as I said, some information, background information on the project on which this webinar is based. It's a project called Child-Friendly Justice in Action. It's funded by the Erasmus Plus program, and it gathers for the first time members of the European Network on Child-Friendly Justice. It is coordinated by Defense for Children International Belgium, and has also as partners 7 other sections, European section of the Defense for Children International. So, but the objective really of this project is to enhance the respect of the Council of Europe guidelines in administrative proceedings related to migration. And of course, we are focusing not only, as you will see, on accompanied children, but also on unaccompanied children. To do so, how did we do it? The partnership conducted a research which is based on a bottom-up methodology, where we really try to get the information from the actors on the field. And so on one hand, we targeted the professionals themselves, and on the other hand, the children. So through interviews, we've developed specific questionnaires, and also through workshops with children, participative workshops, we managed to gather their opinion in order to assess to what extent actually the child-friendly justice principles are applied in administrative proceedings related to migration. That's really the way that we proceed. And at the end of the project, so really soon, we will publish different documents. Each partner will publish a national report. We will also develop, based on those national reports, we will draft a European report, and also a very important toolkit for professionals that we want to make it as practical as possible. And for you to know, and I propose that you save already this date in your agenda, all those publications will be presented during a major event on the 28th of September 2020 in Brussels. Of course, we still have to confirm it 100% depending on the evolution regarding the COVID-19, but we are pretty sure that it will be happening at this time. And so just one last thing before I give the floor to Eva, I just want to mention that part of this project, there is also a really strong advocacy strand on which the two-day webinar is based. And it is supported by the Initiative for Children in Migration, which is an informal collaboration between asylum, migration, and child protection actors at European and national levels. And through this support, we managed to develop also a European position papers, and some elements of which will be presented today during this webinar as well. So thank you for your attention, and without any delay again, I will give the floor to my colleague Eva.
Thank you, Laurent. Hello, everyone. So today this webinar is really dedicated to the implementation of the Council of Europe guidelines on child-friendly justice and how it can be related to a better implementation of the rights of migrant children. So to begin, I will share my screen with you because I have a presentation. So normally you see my screen. Okay, so first, what are the guidelines on child-friendly justice? They were adopted in 2010, and they set up also general principles and really specific rules too, in order to ensure that the rights of the child can be implemented when they are directly concerned by a proceeding. And these guidelines, they were inspired and are very much in line with other international references, other international standards, such as the UN Convention of the Right of the Child or the European Convention on Human Rights, etc. First of all, I would like to present you really quickly the key principles of child-friendly justice that are embedded in these guidelines. So first, I would like to focus on the first thing here, the rule of law and legal counsel. So child-friendly justice involve that elements of the due process are respected for the child, and it is very much linked to his access to legal counsel. Secondly, let's focus on information and participation. So the child has the right to accede to and receive an adapted information, adapted to his or her age and maturity, especially. And it is really linked to participation, and participation of the child must also be adapted to him or her and his or her age and maturity. For example, concretely for the participation, we can mention that during hearings, the questions that are asked to the child, the setting, the timing, and everything has to be adapted. Then we can see the best interests of the child here. So the best interests of the child should be, first of all, duly assessed, and then it should be a primary consideration in every decision that can affect him. Then dignity is an essential principle of the child-friendly justice. So during all the proceeding, the dignity of the child should be respected. He should be treated with respect. And it also includes that he or she should see her physical and psychological integrity respected. And then protection from discrimination. So it's really important. And in the case of migrant children, it could also include sometimes the need of a specific protection or specific assistance. So those are the general principles of the child-friendly justice. when do they apply? So these guidelines, they are supposed to apply in all proceedings that involve a child, whether he is an applicant, a victim, a perpetrator. His or her role in the procedure doesn't matter. These principles must apply to every administrative or judicial proceedings, including migration-related proceedings. And in the end, the principles are very important in the child-friendly justice principle, are very important in the case of migrant children for many reasons, but especially we should mention that for migrant children, their exercising their rights really depends on a lot of different proceedings. It can be family reunification proceedings, asylum proceedings, and everything. That's why we see a strong and direct relation between exercising their rights and proceedings being adapted and child-friendly. So we identified during the research that Laurent mentioned still a lot of gaps and obstacles that prevent these proceedings to be child-friendly. It relies on, for example, the lack of child-friendly information, or the lack of participation of the child, or often when children participate, they are not heard in an adapted way, or it can rely on the duration of the proceedings, etc. So we chose to focus on three thematic and country-specific focuses in order to enter more concretely in this matter. So I will stop sharing my screen and give the floor to my colleague Giulia from Italy for a focus on the important role of the volunteer guardian. Giulia?
Yes, thank you, Eva. Thank you very much, and hello to everyone. I can see your names, not your faces, but I guess you are there. And I will also share my screen. Okay. It is just like a support for my presentation. So the topic that we chose for Italy is the role of volunteer guardians in protecting the rights of unaccompanied children in Italy. Why? Because this is a very practical measure that shows how it's possible to strengthen the respect for procedural safeguards of unaccompanied children. So it is a very practical proposal and that we would like to share, because I will start by introducing the legal framework, the legal reference for this model, which is Law 47. It's a very advanced law that is called Provisions on Measures for the Protection of Unaccompanied Foreign Children, which came into force on April 2017. It is a very important provision in the Italian legal context on migration, since it reaffirms some fundamental guarantees for children arriving alone in our country after a migration journey. So these guarantees include important developments, such as the prohibition of expulsion and the right of residence permit for each unaccompanied child, that the timing of the first reception phase that should be limited to 1 month, and the holistic and multidisciplinary age assessment procedure, the presence of the cultural mediator that should be present in the various procedures, the national information system for foreign minors, and that gathers data and information useful to determine the most suitable long-term solution, etc. So you see that this is a very advanced law that is very in line with the CRC and all the provisions on child-friendly justice. This law also strengthens foster care and community-based responses, such as volunteer guardians, who should be timely appointed after a child has been identified as unaccompanied. So I will focus my intervention on this role of the volunteer guardian, and that is introduced by Article 12 of the law. And the volunteer guardian is a citizen, is a private citizen, is a volunteer citizen who, free of charge, assumes the role of legal representation and also to monitor the best interest of the child in all decisions that concern him or her. So it is like an expression of civil commitment. It's a very innovative measure because it introduces in the reception system an independent presence that is there to act as a watchdog of the rights of the appointed child. It's therefore free of any conflict of interest. It's not part of the system. So the law identifies a system, which is a model, which is the regional ombudsman that has the responsibility for the recruitment and training of citizens, and then the juvenile court that has the responsibility of managing the lists of volunteer guardians and appointing them. So now after 3 years of implementation and observation of this model, we can say it's clear that this model represents a powerful tool of protection and representation for unaccompanied children, and above all, it is individualized. Because when they are not assisted by a volunteer guardian, in fact, children are appointed with an institutional guardian, which is often a public official of the local administration, but it is quite clear that this is not sufficient to ensure individualized support. Often there is conflict of interest, and there is not a full respect for their rights, and it's very difficult in this case to ensure an effective path of integration. So only a specifically dedicated person, in fact, can have the interest, the motivation, the material time necessary to assist the child throughout the bureaucratic process of the application for international protection, for example, which has become increasingly complicated in Italy by the latest national provisions. In fact, in the vast majority of cases, as you know, we are talking about people who have undergone difficult experiences, even very strong ones, who don't know the language and who therefore have great difficulty in continuing their studies or finding a job. And these are indispensable conditions for emancipating themselves and integrating into our society. So this presence of this citizen that is next to, as you can see in this picture, next to the child, we believe it's very important in general for an unaccompanied person, children that is in our country. So a very important thing that that we should say is that in turn, volunteer guardians need to be trained and support, of course, and this is something that it's a bit weak at this moment, but that could be reinforced, and there are some projects working on that. So after this introduction, I will very, very briefly, in 5 minutes, try to show how the role of volunteer guardians can strengthen the application of the child-friendly justice principles already presented by Eva. I have chosen some elements of the child-friendly justice, and I will introduce every principle with a quote from an unaccompanied child related with the role of the guardian. These are some quotes that we collected during our research. And I will start from the right to information. So a guy says, let's hope all the minors have a guardian because all the kids need help to get by. And the guardian gives you courage. So the volunteer guardian is the legal representative, as we said, and therefore accompanies him or her in all judicial and administrative proceedings. So his presence qualifies the child's rights to information during administrative procedures, because normally the guardian talks to the child in a language, of course she understands or he understands, tries to make sure that the child has understood everything, verifies that if the child would like to receive some more information, and sometimes acts as a bridge between the child and the information provider. So the volunteer guardian also supports the child in expressing him or herself and in understanding the world that surrounds him, what's happening, because we know how disorienting is the system sometimes for these children. So this is extremely important, given the fact that in general, there is no systematic presence of cultural mediation or interpretation in the framework of an administrative proceedings. Another element of the child-friendly justice is the right to access to remedies. A boy says, in the residential care facility, when you have a guardian, they are a little scared because they know there's someone behind you. If they do something wrong, the guardian goes and says it's not right. The guardian goes straight. So in case of, and this is very, I mean, it's someone there that acts as a watchdog, is there to safeguard the child and his or her interests. So in case of appeals, for example, the guardian informs and supports the child about this option, because sometimes otherwise they don't know which are the options available, monitors the evolution of the application, including and eventual appeals, monitors the deadlines, and with the support, of course, of a lawyer if it's necessary. And the volunteer guardian helps also the child at finding a lawyer when it's needed, and acts as a bridge between the child and the lawyer, trying to help the child at getting oriented. The right to participation, another very important element of the child-friendly justice, says a boy that with the guardian, I am not ashamed or afraid to talk. What comes into my head, I just say it. So this is very illustrative, because it shows how guardians are there very close to the child to make his voice heard and taken into consideration also in the decisions that concern them. So in an administrative proceedings, the child is listened to, as we know, in an extremely formal way by institutional actors. We know that sometimes children say what the professionals want to listen. So the volunteer guardian is there also to underscore the importance of children's meaningful participation in all procedures and decisions that affect them. And we have to think that this model is very much based on mutual trust. And trust is a fundamental requirement for genuine participation and for meaningful participation. The right to protection is another very important element of child-friendly justice. The guardian is always there, always trying to help you. It is like seeing your mother. She will never put you in danger. This to say that the guardian plays a key role in verifying that all procedural safeguards, all guarantees are in place, and when needed, he or she, the guardian, should act to claim for the application, for the proper application or improvement of the conditions and of the safeguards, including with the support of a legal assistance if necessary. So for example, one procedure foreseen by the law 47 that I was talking about is the possibility for children to request an extension for prolonged support within the child protection system until the young person is 21 years of age. This is to ensure a successful path of social integration. So from the analysis that we did, it emerged that there is a general reluctance of local social services, for example, to use this measure due to interests other than the best interest of the child, such as financial constraints, for example. But so we know that unfortunately, different institutional approaches, logics, and priorities constitute a key obstacle for the respect of the rights of the child. The lack of well-defined responsibilities and accountability mechanisms that give place to a system of diffuse responsibilities in which there is no final responsible for violation of standards or infringement of norms. And the volunteer guardian appears in this context to protect the child, to raise the voice against these dysfunctionalities of the system. So we are talking of situations where institutional actors are acting according to interests other than the best interest of the child, and they are the ones who should be defending and protecting the best interest of the child. So that the volunteer guardian has also this function. And this brings me to the last point, which is the principle of interest of the child, of course. And a guy says, the guardians help your thoughts too. When you don't have anyone to help you, you think a lot. You think about much bigger things than yourself. If you have a guardian, you find a person who tells you not to worry, I am here. The guardian gives you peace of mind. And it's important because when you don't have peace of mind, you go crazy. So the very important thing also is that the volunteer guardian is an element of continuity. It's a human presence, of trust, in a system that many times is adult-centric, as we know, and doesn't consider the specific exigencies of children or young people. So as a matter of fact, the way in which the system perceives and recognizes and accompanies children many times is highly standardized and even stereotyped. So guardians who have no other interest than doing the best for the child are there also to bring a bit of common sense and humanity to a system which is very complex, very, very complex and very far from the perceptions and the sensitivity of a child. So I think I will stop here my intervention. I am sure that we will have the possibility after to respond to questions or reactions. And I will give the floor now to Spiros from Greece. Okay, stop share. Thank you.
Hello to everyone. This is Spiros Peris from Defense for Children International Greece. I have prepared a presentation focused on what's happening in legal representation of unaccompanied minors in Greece, but also have extended my presentation to similar issues in order to show what is the situation in the field for unaccompanied minors, which is very difficult. And I have prepared some proposals which are referred to Greek authorities and European authorities on behalf of our organization. And we are going to advocate for these proposals. So I'll start sharing my screen, which is text. You can read the text, and I scroll down in order to see the whole text. Sorry. Just a moment, please. I think you can see it now. I'll start my presentation. The situation in the field. This presentation aims at assessing the gaps of shortcomings and of the judicial system applying to children in migration, and at providing meaningful and practical proposal to the Greek and EU relevant authorities. In fact, there is not effective implementation of the child-friendly justice guidelines of the Council of Europe in Greece because of various serious systemic problems in the reception and asylum procedures and the function of relevant authorities. There are serious challenges upon arrival, which happens through irregular entry from the land or the sea with or without smugglers. There are no border points for officially applying for asylum. Some children do not have access to asylum authorities and remain homeless for uncertain time. Additionally, there is no transparent procedure of the age assessment of the children, which is doubtful that they are informed properly of their rights to challenge timely the decision. Most of the times, there is no guardian present in the procedures needed in order for the children to have an asylum claim. There are delays which reach to 1 or 2 years in many times in the asylum procedure, and the children become adults in the meantime, and there is no unanimity how they should be treated in asylum procedure if during this procedure become adults. Sometimes there are no access to accommodation after registration of their asylum claim due to lack of proper shelters. At the islands of Eastern Aegean Sea, there are allegations of rape and sexual exploitation of children. The children may receive inadequate first reception, identification, and registration services while residing for prolonged periods of time in reception and identification centers in the islands of Eastern Aegean Sea near Turkey. The way in which these services are provided and procedures are followed often infringe the children's rights to proper identification and registration, and they fail to implement assessments that reflect children's best interests and or provide culturally and age-appropriate information and legal representation. Children in so-called the jungle of Moria in the island of Lesbos do not have access to information about their possible family reunification, so they run the risk of missing the deadline of proceeding with due to deprivation of free legal representation. Their Dublin claims for family reunification are rejected by European countries, more often on doubtful and non-legal ground. And many children are homeless and without proper access to the asylum procedure, and most of the times there's practically no guardian to represent them in the asylum processes, and especially in the Dublin process. The free legal aid, which is supposed to be provided by law, is available for few asylum seekers, including the unaccompanied minors, especially at the islands of Eastern Aegean Sea. Legal representation is paramount for these very first moments of identification of a child, and this representation will enable the children to escape invisibility, get back to a context of normality in their life, and exercise effectively their rights to registration and representation by a lawyer in asylum process, and of course the right of family reunification. Children in Athens are homeless and unregistered. Without proper information, they will remain in the hands of smugglers. DCI Greece, Defense for Children International Greece, has been conducting information sessions in key areas of the city, informing them about their rights and taking over their legal representation. In cases, age assessment procedures do not follow the appropriate guidelines, and in other cases, children are misidentified as adults, thus forced to live among unrelated adults in the reception centers in inappropriate living conditions without receiving child protection services they need. There are also 330 children who are now currently detained in police stations and detention centers, and more than 3,000 children out of totally more than 5,000 children who live in uncertain and unsafe conditions without access to many of their rights according to the Convention of the Rights of the Child. And now I come swiftly in certain proposals we have prepared for and presented present them to you. So according to the above mentioned, there are urgent needs to be accomplished by the state authorities, which are now well addressed by the relevant Greek and European authorities. Greek authorities should prioritize a sustainable long-term child protection strategy based on the best interests of the child and the provision of durable solutions, while reinforcing the implementation of National Action Plan for the Rights of the Child. Provide meaningful access to legal aid for all children, and increase the capacity of the Dublin unit of the Greek Asylum Service to help speed up the family reunification. Implement the new legislation on foster care and guardianship as soon as possible. There is a legislation in place, but the system hasn't started working yet, so there are no state guardians for any children in Greece. Provide protection services to unaccompanied children living in the streets. This is very important. These children are invisible, are homeless, and should be absolutely the absolute priority in the referral mechanism of National Center for Social Solidarity in Greece, providing them with a safe shelter. Put an end to protective custody, in fact, detention in police station cells, and ensure effective child protection. Step up efforts to take all children and their families out of overcrowded facilities to appropriate safe accommodation. Now, the European Commission should encourage and support Greece to implement all the above recommendations, and in addition, create improved and more transparent funding procedures so that member states can allocate the funding to the governments and local implementing actors and civil society organizations in the best possible way and for all set priorities. Improve monitoring and accountability mechanism for EU asylum, migration, and integration procedures and funding. Urge EU member states to implement speedier and more flexible family reunification procedures in line with the EU directives and the Dublin regulation, having the best interests of the child as a guiding principle throughout the process. Establish steady and reliable relocation mechanisms for children from Greece, Italy, and Spain to other European countries, and for the burden sharing of the arrivals of asylum seekers in European Union. And finally, the EU member states should examine family reunification requests having the best interests of the child as a guiding principle and proceed in the adoption of bilateral agreements with other EU member states following the example of the UK's DABS scheme to increase relocation pledges for refugee children. Finally, I want to stress that as you can see in my presentation, there are very few rights for unaccompanied children in Greece that they can exercise effectively. So the role of the legal representation and legal aid from the beginning of the process is very critical, and that's why we need this the NGOs and of course the state legal aid, which is obligatory and is very is available only for few children to be effectively implemented. Thank you very much, and I pass the floor now to the next speaker.
Hi, thank you, Spyros. Okay, we'll now present a focus on Belgium and on the research we led in Belgium. So it was focused on especially international protection proceedings and children involved in these proceedings with their family. So I wanted to start, as my colleague did, with a small poll. So my first question for you is, in your opinion, what proportion of the files introduced in Belgium in 2018 for international protection involved children? So including children in family and children, unaccompanied children. My second question is, in your opinion, what does Article 3 of the Convention on the Right of the Child provide for? So in all actions concerning children, the best interest of the child shall be considered or shall be a primary consideration unless he or she is a migrant, or shall be a primary consideration. Thank you for your participation. And you know very good the answer for a majority of you. So I will now share my screen for my presentation. Thank you. So indeed, in Belgium in 2018, among the almost 20,000 applications for international protection who were introduced, 31% involved children, 27% involved children in family, and 4% unaccompanied minors. And regarding the UN Convention on the Rights of the Child, so of course Article 3 of the CRC do not differentiate between migrant and non-migrant children. So in all action concerning children, the best interest of the child shall be a primary consideration. Not only it shall be considered, but it shall be a primary consideration, which means among all the consideration that will weight on the decision, the best interests of the child shall be a higher consideration. Therefore, my first conclusion is that in all decisions on international protection that concern a family, including children, the best interest of the child or children that are concerned must be a primary consideration. And so it leads us to a first question, which is, what is the best interest of the child? So thanks to the UN Committee on the Right of the Child and their general comment number 14, which is really precise about the best interest of the child, we start by saying that it's a threefold concept. First, the best interest of the child is a substantive right, which means that every child has a right to have his or her best interest taken into account. And then it's a rule of procedure too, and it's an interpretative legal principle too. And the best interest of the child, it should be assessed and determined for all individual decision, including a decision that concern a family. It's an individual decision too. For all individual decision, the best interest of the child or the children who are concerned, it must be assessed concretely for the child. And so this assessment will include the child's view, the child's identity, how to preserve his family environment. It will include consideration regarding his or her safety, protection, if he or she meets situations of vulnerability. And also his right to health and education are important in this assessment. So best interest of the child is a really concrete, needs a really concrete assessment in every individual decision and is not something general. What about Belgium? So more concretely, in Belgium, since 2018, DCI Belgium has led a small-scale study on children in family who are involved in international protection procedures, so asylum procedures. And it was a documentary research, and it also include participation and interviews of some professionals and some children. So it was not a large-scale study, and it should therefore not be interpreted as such. It did, however, allow us to identify some trends, and I would like to mention some elements of the research, especially about the best interest of the child. So we identified other things, but I would like to focus on the best interest of the child. One of the first elements I would like to mention is that when the professionals who responded to our survey, they were asked one question about how they consider that the key elements of the best interest of the child I mentioned before, such as the child's view, family, right to education, health, and everything, how this professional, how do they consider these elements are taken into account in the final decision regarding the family. And we can see two trends, that most of the professionals who belongs to decision-making authorities who responded to the survey responded to us that these elements are taken into account in a quite significant way in the final decision, which is positive. But in the other hand, the lawyers of the families, to the same question, they responded that they consider that these elements of such as the child's view, his right to education, health, family, and everything have a very little weight in the decision of the administration. In another way, we had the opportunity to conduct some workshop with some children who have been involved with their family in Belgium in in such proceedings, and when we ask them about how their view has been taken into account. So we ask them, for example, were you invited to express your opinion before the decision was taken? Because of course, for the best interest assessment, the view of the child is really important. And half of them responded that they were not invited to express their opinion, and the other half said they do not remember having been able to express their opinion. And then another element of the research I wanted to share with you is that we interviewed the professional after the survey, and we gathered some more trenchant testimonies during the interviews than with the survey. And in particular, we have testimonies from a judge and a lawyer who mentioned that in family cases, when the parents are the applicants, often the child or children who are directly concerned are not very taken into account. And in some cases, they are even invisible and completely ignored in the decision-making process. So I must say that the observation on this subject is quite mitigated. So in one hand, we can definitely see improvement in how the child's best interest is considered in the decision. But in the other hand, we can also see that in some cases, the child or children are not even seen in the assessment of the file. And we also see that there is still no systematic assessment of the best interest of the child, nor systematic motivation of the family decision, of the decision for the family. So decisions for families are not always duly motivated under the best interest of the child. What I could say on this is that the child-friendly justice guidelines provide us with useful information on how to better take into account the best interest of the child in these proceedings. And one first element is that I would like to mention is that often when a family applies for international protection, it does not only concern one child, but more than one, but children. So the best interest of all the children concerned should be assessed separately and weighted, as mentioned in the child-friendly justice guidelines. Also, I would like to mention that the best interest of the child is really related to all the other principles of the child-friendly justice, such as the due process and access to legal representation, the right to be heard, of course, but also the protection of his or her integrity and the protection from discrimination. And they are really code-dependent principles that should find a way to apply in all proceedings in a coherent way. In order to conclude on Belgium, I would like to say that we identify 3 lines of action that could be useful to enhance how the best interest of the child is taken into account. And first, I would like to mention that as a first step, child or children should never remain invisible in the process. It's like the first step to their best interests being taken into account. Then, of course, systematic, independent, and multidisciplinary best interest of the child assessment should be settled, and all the decisions regarding international protection should be duly motivated, taking into account the best interest of the child. And in the end, more globally, it would be necessary to adopt and to be careful that the whole system is coherent and protect the best interest of the child and do not lead to children's rights violation. But it certainly needs a broader change of perspective and it really needs to always put the child before his or her migration status. So I will stop sharing my screen. This is what I wanted to mention regarding Belgium. And before going to the Q&A session, I wanted to have to move from Belgium, to leave Belgium a little bit and to adopt a more European scope. Because I think across these three focuses we did in Italy, in Greece, and in Belgium, we really wanted to be more concrete and more explicit on how the rights of the child are not respected during proceedings. But in the end, migration-related proceedings are really a European issue. So we should try to take this step too. And indeed, it's a European issue because European Union has a lot of competencies in the field, especially due to Article 77 to 80 of the treaty and the functioning of the European Union. And the consequence of it is that a lot of European regulation have a direct impact on these proceedings. So it is the case of all the common European asylum system, which includes the qualification directive, the directive on procedure, also the Dublin regulation and Eurodac regulation, but it also includes other regulations such as the return directive or more punctual agreements such as the Greek and Turkish agreement of March 2016. Well, I'm not going to mention all of them, but just to be aware that a lot of EU ruling directly affect what we mentioned before and is therefore really relevant in this context. And I just wanted to mention three ongoing EU processes that are relevant in the field. And that are ongoing now and that might have a big impact on these proceedings tomorrow and on the right of the child in these proceedings. So first of all, there is the new Pact on Asylum and Migration, which is ongoing in the European Commission. It was supposed to be adopted in the end of, well, in the beginning of 2020, but I think it is still ongoing. And so this is a document of the European Commission. And maybe in another step, it could be the base of legislative change at the European Union level. Another process I wanted to mention is the current recast of the Return Directive. The Return Directive had direct impact on many of the elements that my colleagues had mentioned. And in the end, of course, the reform of the Dublin regulation, which has a direct impact on proceedings. I would really like to thank all of you for attending this webinar, and I hope you found the information you wanted to hear. And I will give the floor to Vesna in order to go to the Q&A session.
Thank you, Eva. Thank for all the presenters. It was really interesting, and I saw that it was really active in the chat sessions. There are questions for all of the presenters. I would like to invite you to share your video again and open the microphone. I saw that there was also two questions for Spiros, but he answer it also in the chat section, and he got two, I believe, two follow-up questions for that. Maybe Spiros, to start with this part, with this question, is it okay for you to answer it? Did you saw it in the chat, the new questions?
Yes, okay. There were some questions about the violations of the rights of children in Greece, especially in the intention concerning their detention and the overcrowding of the people in the islands. There are repetitive decisions over the European Court of Human Rights through the Article 39 process, which is a swift process for urgent cases. And the court accepted that the conditions the children live in reception centers in the islands and in detention centers in these specific cases are unacceptable against the legal framework of about children, and ordered the transfer of the children to safe places. These decisions have been implemented, but only for the concrete children. There is no structural change for the time being. There's a new draft law that will be introduced next month in Greece and provides for a new secretary for unaccompanied children. This is a completely new state authority. It's a good step, but we'll see how this works, because this secretary needs people and infrastructure to function, and there's no information that this will happen soon. The other thing is that there are repetitive also decisions of the European Court concerning the detention of children, and of course the court ordered that this detention should end and the children should be transferred to safe places. And this has also these decisions have been implemented, but only for specific children. Now, as I told you in my presentation, until yesterday, we have 331 children in detention centers and detained in police stations.
Okay, thank you, Spiros. Thank you very much. So we don't have a lot of time, so I will just use this moment to give now floor to Eva. Eva, there was a question, a few questions, but there was a question for you. I don't know. Did you see it? The question was: does the recent jurisprudence, I'm very sorry if I'm pronouncing it wrong, on the Committee on the Rights of the Child against Belgium, which is also related to the migration process, has any positive impact on the administrative judicial process in the country, also in order to understand its effectiveness? I'm not sure. Okay, you're here.
I've seen the question.
Yeah.
I must say I do not know, and especially because this decision regarded more other type of resident status. It was not on asylum proceedings, so it was not exactly on the scope of our research. But it could be really interesting to study this. And as the decision is quite recent, I'm not sure it has impact today, but we should.
Okay, and also there was for you, is the study in Belgium reflecting points about BIC available online?
Yeah, I saw this question, and no, it does not. And if you have more information to send us on the evaluation of the BIC online, I would be interested.
Okay, great, thank you. And there was, of course, in the beginning, a lot of questions for Julia. Especially regarding the volunteers. I would like to read a few of them. So what are the requirements to become a volunteer guardian? Is it a legal background required? Plus some questions about the number of volunteer guardians. Do you have quantitative data on that?
Okay, so regarding the first question, and the law 47 don't establishes like some criteria, but identifies the national ombudsman as the actor that should monitor all the model and the system of volunteer guardians. So the national ombudsman for Children and Adolescents has issued some guidelines at national level on selection and training of guardians. And then each regional ombudsman should like select and train candidates. And normally there is an interview and a procedure, but it is not an uniform procedure at national level. And this is a very, very important aspect. And for example, from DCI Italy, we are trying to like push for reinforcing all this selection process. But of course, we are talking about a system that is also monitored by the juvenile court. So we have a judge there that is overseeing also the performance of the guardians. And we have other actors in the system, social assistants and other social workers that are there also to cooperate and collaborate with the guardian. But yeah, of course, there are some criteria and some that should be strengthened according to our point of view.
Okay, I believe your answer also connects with the question, how does the law protect children to guarantee that they're not trapped with the bad guardians?
Yeah, of course, they ask, they have to present their criminal records and so on. There is a selection and an interview, but you don't need to have legal background, for example. This is something that the training theoretically gives you the basic notions to be able to perform this role. Because volunteer guardians are not like professionals, actually. They are citizens, volunteers that are next to the child, and that they can, of course, be supported by other specific competences of the system of, for example, legal advisors, lawyers, and so on. They don't have to know everything. It's not possible. They have to be a citizen which has an exemplar, let's say, a good attitude, a good sensitivity, and that common sense, and that is willing to support the child. And of course, there are some requirements, such as the criminal record and some others, there to ensure that is a suitable person, of course.
Great.
It's very important.
It's really nice that the people doesn't need to have this legal background, that it can be a regular person who has a motivation to help the child and to be support for the children. It's really nice. So I believe that also people were asking also about the education of the volunteers. So there is an interview and also psychological, I believe, questioning of the people, because there was a question about this is
depends a lot on the region, because it's a model that it's organized on a regional basis. So each region has its own way of working, let's say, and each ombudsman establishes its own system. But of course, the training for guardians has like minimum notions that and psychosocial aspects are covered normally, legal aspects, of course, aspects regarding the migration phenomena, the referral system, and so on, and protection against violence and against some phenomena. And what I wanted to say, I don't know what was the other aspect.
Psychological. It was the question about the also psychological aspect. So
of the guardians.
Yes.
No, there we have normally there should be an interview by the regional ombudsman. Normally, I'd say normally because there is no an uniform and as I was suggesting system. But normally there should be an interview done by expert people before being appointed and being registered in the list of volunteer guardians. There is an interview that tries to assess the suitability of that person.
Okay. Okay.
And regarding the ratio between the presence of unaccompanied children and the number of volunteer guardians available, there are no up-to-date data. The last data we have issued by the National Ombudsman are from the end of 2018, and registered in the juvenile courts, we had 3,029 volunteer guardians.
Okay.
Now there is a study that monitoring study that will be issued very, very soon. Also in English, I will write you the link where you can find all the results. But now we have to think that more or less that now at this time we have like 5,000 and more, yeah, a little bit more than 5,000 presences of unaccompanied children in Italy. For example, in Liguria, which is the region that DCI Italy operates and is in charge of the training for volunteer guardians, for example, we have covered more or less 40% of the presences of unaccompanied children. And of course, the willingness and the objective is to cover 100%, of course.
Okay.
But it's an ongoing process.
Yeah, yes, yes. Okay. Thank you, Julia, for the clarification and all the answers. I believe we have gone a bit through the time of the webinar, but I believe it's for the really good and great purpose. I would just like to share for the end a small evaluation poll. Just a second. If you could really give us a feedback, this would really help us. Just a second. And also, if you would like to get a certification of attending this webinar, you can write to the email of the Child Hub. I will write it in the chat box. If you can just be a little patient, you will definitely receive it back on your email, but it's only a few of us who are working on that, so sometimes we need time. And also, final note that this webinar was recorded, and I believe it will be available on the webinar page of the Child Hub by the end of the day. It will be uploaded also on the YouTube. So I would also like to thank again to all the presenters for their great work and their great presentations, and also to thank you for coming and being with us with this 70 minutes today, and wishing you a really nice rest of the day. Goodbye.